Welcome. This is Bill Larson and Rob Vanderweel of Profit Protection Risk Management Consultants. We would like to welcome everyone to this VIA webinar being done in partnership with Weinsergi Insurance. Today, we will be discussing ways to help you to protect your company from the compliance and liability exposures which have been created by FACTA and the HIPAA high-tech law. My background is 40-plus years in the insurance industry, with the last 10 years being concentrated in the areas of data breach liability, identity theft, and compliance. My partner Rob has also concentrated on the areas of data breach and identity theft for an equal amount of time. I am currently serving as the national chairperson for the Independent Insurance Agents and Brokers of America Agents Council for Technology Work Group. This work group will ultimately help the IIABA members to better understand their exposures under the HIPAA high-tech law so that they can properly protect their clients and their agencies. In addition to this, we have also developed programs for and been endorsed by the Independent Insurance Agents of Illinois as well as other associations. Now, I would like to turn this program over to my partner Rob.
Thank you, Bill. Today we're going to be talking about protecting your assets, yourself, your company, and your employees. And there will be a lot of information here today. Our goal is just to summarize the exposure and your obligations you must meet under HIPAA high-tech and FACTA, and give them to you in a clear way so you understand that there are actions we all must take to protect this information and, of course, our businesses. Data breaches affect over half of the small and mid-sized U.S. firms, and that's from business insurance. There's a lot of personal identifiable information, protected health information, PHI. Businesses of all types and sizes, as well as individuals, are vulnerable to costly and damaging liabilities from data security breaches. Breaches are happening at an alarming rate. If you visit Privacy Rights Clearinghouse at privacyrights.org, you'll see that there's been over 607 million data records that have been compromised, and these are American identities that have been compromised since January of 2005. So statistically, it means that every individual across our country has had their information compromised almost 2 times. Why your company needs protection? Well, there's hackers, there's viruses, there's disgruntled employees, there's lost or stolen laptops, computers, cell phones, or even regular paper files. And a single data breach can have serious ramifications. There can be financial costs, government fines, lawsuits, and damage to your company's reputation. Coverage is not provided under your general liability or umbrella policies. You need data breach cyber liability protection. We know we must secure our customers' and employees' non-public personal identifiable information, and if you're not compliant with the current data breach laws, most data breach liability insurance policies will not provide coverage for your company. To fully protect your company, your data breach policy must cover government fines, breach notification costs, and data loss at your company. It must also protect you if those with whom you share the private information or private health information are breached or lose your information. If you do not have business associate agreements in place with those with whom you do business, you're not in compliance and are open to significant liability. So when do you need a business associate agreement? When do you need a vendor agreement? When do you need an independent contractor agreement? And who's who? A covered entity is an employer who's the plan sponsor. A business associate is an individual or a company who does business on your behalf, like an attorney, a CPA, an insurance broker, etc. A vendor is an individual or a company from whom you buy something, cleaning service, computer service. And a person is an individual who does work for you but is not an employee, therefore is an independent contractor. So how do you decide when you need a business associate agreement? This chart, VIA, can provide you if you want to go through the steps to really determine when you need a business associate agreement. The points we'll cover are companies that possess private information, health and personal, about employees and clients are mandated to protect that information by the HIPAA high-tech law, which was further defined by publishing the final rule in January of 2013 and also defined by FACTA. Traditional insurance products are inadequate to cover the new types of events that can result from a privacy invasion. Organized crime is one of the driving forces behind the data breach losses. And once information is sold into the black market, that protected information, this exposure creates the potential for an unlimited number of claims over an unlimited number of years, and this creates a potentially unlimited liability exposure. That's why it's very hard to insure. So how do you manage a risk in which the claims potential creates an unlimited liability exposure? Well, the biggest point is the risk must be removed. And the only method to achieve this goal is to use a restoration program in which the breached individual is returned to pre-theft status. And once pre-theft status is achieved, pre-identity theft status is achieved, the breached individual's liability loss is mitigated. So is your business properly protected? The potential exists for this unlimited liability exposure to your business. Once your breached non-public information is sold into the black market by organized crime, it can be bought and sold forever, creating a potentially unlimited liability situation for you and your business. Employer liability and compliance. First, from the United States Department of Health and Human Services, this is January of this year, if an employee provides benefit plans that meet the definition of a group health plan, then the employer steps into the role of a plan sponsor and therefore must take steps to achieve compliance with HIPAA. From the U.S. Department of Commerce, these are absolutely necessary actions that a small business should take to protect its information. From the U.S. Chamber of Commerce, the obligation for dealing with threats to a business's information security rests with each person, from CEOs to frontline workers. And from the Bureau of Consumer Protection, part of the Federal Trade Commission, every company has an obligation to its customers, its affiliates, and employees to safeguard sensitive data, as outlined in the Federal Trade Commission's new handbook, Protecting Personal Information, a Guide for Business. And yes, we will review that handbook in just a moment. The issue is the problem of data breach and identity theft liability. Identity theft liability comes from data loss. The majority of this data is coming from companies. And so now there's new laws, compliance issues, liability, and exposure for employers. And the issue of the data breach and identity theft liability could lead to a serious disruption of your business, lost profits to your business becoming a victim of a government investigation and audit, and of course significant fines, even an unfunded and unlimited liability exposure attached to your business, which can affect future sale and or financing of your business, and of course there's third-party lawsuits. There's two main areas of risk and exposure to this entire issue. The first is the data breach compliance. We all must have written privacy policies, appointment of information security officers, annual compliance audits, annual compliance updates, mandatory trainings, and that's for the entire staff, mitigation plans, documentation and sign-off forms for everything, and vendor oversight. And the exposure on this side is fines and fees all the way up to $1.5 million. The liability risk and exposure is all the actual losses to employees and customers, and all future losses that employees or customers as a result of the breach. There's notification costs, there's defense costs, or attorney's fees we could say. And then there's identity theft coverage costs, which companies are being forced to pay for. There's FTC, HHS, and OCR enforcement costs. The exposure on this side is truly unlimited, potentially millions. But if you add in the vendor oversight, the same exposure applies to the unlimited side. A company or business is not relieved of the liability if somebody they exchange sensitive data with has lost the information as well. They can trace it back. To address this, companies must They have to develop that written security program, complete with all the documentation as defined by FACTA and the HIPAA high-tech law, including HIPAA high-tech policies and forms. Implement this new security program. They have to train the entire staff on the security program. They have to continually audit and update the program as required. Create a mitigation plan that kicks in and repairs damages. And oversee service providers and vendors as mandated by the HIPAA high-tech law in the Business Associate Agreement. Data breach insurance applications. Well, to apply for the proper insurance coverage, you must have these systems in place first. If you look at some of the insurance application forms, you'll see they ask right on there, do you have a written corporate-wide privacy policy? Do you employ a chief privacy officer? Do you have you had training for your employees, your entire staff on privacy and data security and related issues? And in your contracts with vendors, in other words, do you actually have contracts with your vendors? So just to apply for the proper insurance, you have to have already put in these other systems. So let's define the problem. All companies have three types of sensitive information. They have employee information, again, personal and health related, customer, personal and health related, and then they have business associate, which is any sensitive information sent to or from or received from a third party, such as a payroll company, insurance broker, etc. It's a combination of the employee information and the customer information. So how many times can organized crime sell a Social Security number? I think we know that's unlimited, and for how long in the future can they continue to create the liability, which creates a potentially unlimited liability exposure for an employer. This is a great slide just to illustrate how vulnerable the individual is. If we'd all agree that our information is irretrievably out there in all these different databases, utility companies, insurance companies, credit card records, etc., and then again we visit privacyrights.org and view all the different security breaches that have happened to all the different U.S. Firms, etc., since January of 2005, first, what most people end up finding is places of business that they've done business with that have actually had these breaches and lost their personal information. So again, 607 million American identities have been lost or compromised just since January of 2005. So the conclusion is simple: you can't prevent identity theft. There's 5 common types of identity theft, and the reason we break this down to an individual level is so you can understand your exposure when a data breach happens and a big chunk of sensitive data is lost or stolen and put out there into the, quote, black market. So there's driver's license identity theft, which is a photo ID. Social Security identity theft, that's kind of a window in your life. They can open up bank accounts, do all kinds of things with your Social Security number, even get jobs in your name. There's medical identity theft. If someone's A positive and you're O negative and they've used your sensitive data to gain treatment, you could actually receive the wrong blood or drugs, and that result could be very harmful. There's criminal identity theft, somebody simply committing a crime in your name, whether they do it over the internet or in person. And then, of course, there's financial identity theft. That's what we hear the most about on the television and radio. But that is currently about under 20% of this entire identity theft problem. Identity theft is not just about credit cards. It's really a legal issue, and over 70% of the time, access to an attorney will be critical to resolve these issues. The Federal Trade Commission put out this guide, Protecting Personal Information, a guide for businesses. And on page 5, are there laws that require my company to keep sensitive data secure? Yes, there are. To comply with the law, what must I do? Well, you must develop a written record retention policy. The most effective data security plans deal with physical security, electronic security, employee training, and the security practices of contractors and service providers. Sounds familiar, like what we just reviewed. It goes on to say that you must create a culture of security by implementing a regular schedule of employee training. And make sure you train all the employees. And ask every employee to sign an agreement to follow your company's confidentiality and security standards for handling this data. Under business associate and vendors, which is what it applies to, your company's security practices depend on the people who implement them, including the contractors and service providers, whereas you exchange that sensitive data with. So before you outsource, investigate the company's data security practices and address security issues with your service providers in your contract with them. Make sure it's spelled out clearly. From HHS.gov, right from the U.S. Department of Health and Human Services, these are actions that employers must take as required by the HIPAA HITECH law. There are 6 specific actions that should be taken to demonstrate a good faith effort, embark on a roadmap to compliance, and of course achieve compliance. So you have to establish this privacy and security risk management governance program as required by 45-etc. Complete a HIPAA security evaluation as required by the law. Complete a HIPAA risk security analysis as required by. Develop a comprehensive privacy and security and breach notification policy and procedures as required. Complete a privacy rule compliance assessment as required. And then, of course, document and act upon a corrective action plan. All these are very similar to everything we've just reviewed. The safeguards. Well, HIPAA HITECH requires that covered entities, employers, safeguard protected personal health information in 2 ways. Administrative, technical and physical safety for PHI, that's on paper. So all the paper files, there has to be systems in place. Then, of course, electronic safeguards for the protected health information stored or processed by computers. All the information is either electronic or on paper. The general rules for HIPAA HITECH privacy compliance. There has to be administrative oversight, authorization to release information, a privacy notice, individual privacy rights, minimum necessary policies and standard forms, audit of privacy protection procedures as defined by HIPAA HITECH, and business associate agreements must be in place. Again, a lot of information, but we're here to help with all that. The rule is simply this rule number, the 164.504, the business associate agreement as required by HIPAA HITECH. And this is the definition. Any person or organization who is not your employee but does work on your behalf and could have access to this protected health information. So there's fines and liability exposures. Your company is liable for the loss of data by your business associate. Your data breach liability policy must extend coverage, your insurance policy must extend coverage for loss of your data by your business associate to afford your company proper protection. And a business associate agreement will help to mitigate your exposure in this area, and it's mandated by the HIPAA HITECH law. And here's a sample of a business associate agreement under HIPAA Omnibus Rule for HIPAA compliance. This agreement is made effective on this date by and between the 2 parties, one referred to as a covered entity, the other as a business associate. And HHS states on its webpage regarding these business associate agreements that the business associate agreement must do 10 things to comply with HIPAA. So here are 5 of the 10, a few examples, because a written contract between a covered entity, the employer, and a business associate must establish the permitted and required uses and disclosures of protected health information by the business associate. Number 2 is require the business associate to implement appropriate safeguards. Number 3 is require the business associate to report to the covered entity incidents that constitute breaches. Number 4, require the business associate to make available to HHS its internal practices relating to the use and disclosure of protected health information for the purposes of HHS determining the covered entity's compliance. And the 5th one provided here, require the business associate to ensure that any subcontractors it may engage on its behalf that will have access to protected health information agree to the same restrictions and conditions that apply to the business associate with respect to such information. So what an employer must do? Well, you have to review all business associate agreements to ensure that they're valid. revise the business associate agreements to include the HIPAA high-tech language, some of which we reviewed. Contact all your business associates and amend the contractual documents, including language, to clearly address the use of protected health information by the business associate. Liability under HIPAA. The basis of liability suits and fines are the federal and state regulations, the statutes and regulations at the state level, internal policies, and of course the breaches of these agreements. New penalties under HIPAA high-tech. Just realize they can be anywhere on the civil side at $100 per violation, up to $50,000 annually, and can go all the way up to $1.5 million for willful neglect that's not corrected. So there's a lot of fines that can be applied. When it comes to training and awareness, privacy and security training pertains to everyone, all levels of the organization. As we mentioned earlier, anyone from the CEO down to the frontline worker, everybody has to be trained on your sensitive information policy and procedures and how you're going to safeguard this protected health information. In utilization of the required HIPAA high-tech policy and forms, that also has to be a part of the training and the entire quote program. Documented training gives management a strong defense in case of a privacy or security breach and is of course a requirement in most of the more comprehensive data breach liability insurance policies and in the HIPAA high-tech law and FACTA. Here is a brief snapshot of all the policies and forms which we can provide you in a toolbox to help you on your way establish this compliance and get that started. The HIPAA high-tech law and FACTA are in effect right now, and your company really must be compliant to mitigate possible fines and liability exposures. We do need to take action. Individual identity theft and data breach products. As we know, once an individual has an issue from a data breach, they're going to need some type of service to help put their lives back together. So there's credit monitoring services that are available out there. This is effective for an early warning of financial identity theft only, and disputing the issues falls squarely on the consumer. Then there is insurance and reimbursement plans. Most insurance coverages offer only reimbursement of certain expenses, and they do not cover the specific loss due to the identity theft. Then there's identity theft resolution services. This service may be limited to only certain types of identity theft, such as financial, and doesn't cover identity theft of Social Security, medical, driver's license, or criminal information. But then there's identity theft restoration services, and a full restoration service will provide a qualified professional to perform the work and to bring the individual back to pre-theft status. Most of these include licensed investigators. This would include financial, Social Security, medical, driver's license, and criminal identity theft, and a true restoration service can save the identity theft victim hundreds of hours of work, and this is by far the best service to have. We take a holistic approach to addressing data breach risk and liability in working with VIA and others. The first thing we do is develop a program as required by HIPAA high-tech and FACTA, complete with the training for your entire staff, the written policies, a lot of the forms and policies required again by HIPAA high-tech and FACTA. Then we move to oversight of your service provider and vendors with establishing, making sure the BA agreements are in place where they need to be. And then we also provide a full restoration program which returns victims back to pre-theft status. And again, we like to say no loss, no liability exposure. And once we've implemented all these, put this entire thing in place with the training and a restoration program, then a wraparound insurance liability policy can be purchased to fully protect it and address your liability exposure. Restoration is the key. Restoration is the key to controlling events that result from a data breach. A restoration program will restore the breached individual to pre-theft status after an identity theft loss. And this is important because when you, your management team, and or your employees are returned to pre-theft status, then there's no direct liability loss. Because there's no direct liability loss, you and your company are then not liable for the direct claims which resulted from the data loss. Thank you. This webinar has been brought to you by Valley Industrial Association, Wine Surgery Insurance, and Profit Protection Risk Management Consultants. We encourage you to contact one of the three today and get information as to how you can act to protect your company, your assets, and your future